Hello everybody. Today's mini rant blog, coming to you from LaBovick, and Diaz, involves a case that just came out 2 weeks ago called Padilla v. Schwartz. The 4th DCA just released a decision on a rear-end injury crash case, and I do not agree with it at all. Let me give you a little bit of the facts. Padilla was driving on the Florida Turnpike here in Palm Beach County. He was driving along, going the posted speed limit in a construction zone. He said and testified in his deposition that there were no cars around him at all, when suddenly, almost magically, out of the blue, Schwartz was right in front of him and he couldn't avoid colliding with the rear end of Schwartz's car. When Schwartz's attorney brought an action against Padilla for rear-ending him, the attorney moved for something called a summary judgment. In other words, moved the court to say, under the laws of the state of Florida, there's no one else to blame but Padilla, and the court should grant them a summary judgment on the issue of liability because under Florida law, there is a rebuttable presumption of negligence when you rear-end one from one car to another. So the trial court listened to all that evidence, read Padilla's deposition, determined that he had no clue how Schwartz got in front of him and didn't see any other cars, realized that there was no other source for blame in this case, and granted the lawyer for Schwartz a summary judgment. They took that on appeal and said, appellate court, 4th DCA, we believe that there's a rebuttable presumption because a jury could find that somehow Schwartz did something wrong based on the evidence that is in the case, only that he magically appeared in front of Padilla. That's the evidence in the case. And the 4th DCA bought that and said, you're right, there is a rebuttable presumption, and we're going to allow you to go back to the trial court and try that case to a jury. Now that's the sum total of what's happened in this case. It has not been retried to a jury yet, but still to know that a plaintiff can get rear-ended, a person can get injured by a rear-ender and have no other excuse except that the plaintiff magically appeared in front of him, and that's enough to take it to a trial, that's just wrong. The 4th DCA should be smarter than that. They should have granted the summary judgment, and I just disagree with this decision. Well, that's your weekly video rant, my new video rant blog. I hope you enjoyed it. Have a great day, and we look forward to serving you if you ever get injured in an accident.